I will call our next case, In re Bates and In re Dailey. This is a mini oral argument on the application, 20 minutes per side. Good morning. You have 20, oh, he's already started the clock. You have 20 minutes. You have time for rebuttal if you reserve it. We ask that you keep track of your time. I may give you a reminder. You know how this goes. And you can begin when you're ready.
Absolutely. May it please the court, my name is Vivek Sankaran and I represent the appellants in this matter. I'm happy to waive my free fire period and would happily invite questions and conversation at any point.
Excellent.
Can I just ask a question that I think that kind of goes to the root of this? When we deal with the lower court's determination, was there error when the lower court did not take into account the mother's strides, the mother's hard work, the mother's efforts? Was that error of the lower court to not take that into consideration, and could that be reversible error?
Absolutely, Your Honor. So we do believe that that was error in two different respects. One, in terms of sort of the strides that my client had made in the Bates matter, but also in terms of the relationship she had with the children. I think that at its core gets to what this case is about from our perspective, which is when can you permanently terminate the rights of a family, of children to parents and parents to children. And our opinion, and what we're asking this court to do, is rule that absent evidence that there is harm in that continuing relationship, that termination is improper. And here, in both of these cases, I think what makes these cases unique are two different things. One is that the children were placed with family, which I think under our statutory scheme, the legislature has said when children are placed with relatives, none of the time requirements for termination, none of the requirements even apply because there's other options available. And second, I think what makes this case unique is the relationship and the evidence of the visits between the parents and the children at the time of termination.
You're not asking us to take the position that just because there is a legal parent involved in one of these cases, that the respondent parent has all the time that they need to address things. At some point, there needs to be permanency for that child. You're not asking us to adopt a position where if there's a legal parent, there's the bar to termination is higher.
We are not asking this court to adopt that. And I think I want to be really clear as to what we're not asking this court to do. We're not asking the court to necessarily extend the time that any parent gets to reunify with their children. We would concede and stipulate that languishing in foster care in a state of impermanence is not good for children, nor do we say that termination is never proper. I want to make it clear in our reply brief, we tried to define that in situations where there's evidence that continuing a relationship with a parent is harmful to that child, that harm could be perhaps the harm of languishing in foster care without any sort of stability. The harm could be a case of serious physical or sexual or psychological abuse that causes then that even the fact of a relationship would harm the child. The harm could be that the parent is absent. And one of the cases that we cited in our reply brief was a parent who was absent for 5 years, and the caseworker testified that reintroducing this parent would inflict harm on this child.
So could the harm be that a significant period of time has gone by where the department and the court are not in a position where they feel comfortable that the respondent parent can have unsupervised visitation, or can have where the department can get out of the case, right? Where they can say, all right, we've brought in services, we've put a plan in place, and respondent parent has achieved that plan, and we can step out. Is there ever a time where there's enough, where the time has gone by, where the harm just kind of adds up, even if respondent parent is doing some of the things that they need to be doing?
Perhaps, and I would perhaps refocus the question of what the respondent parent is doing to the question of what the relationship is and the evidence is of the relationship between the parent and the child. And I want to make it clear that our argument in this case is not that either of these parents necessarily at the time of termination were ready to take physical custody of these children. I think that the evidence was that they both struggled throughout their cases with addictions that were going sort of up and down throughout the case. It's the looking at the quality of the relationship. For example, in the Dailey case, my client was spending 1 to 3 hours a day, is what the caseworker testified, at the grandmother's house with the child, and you have testimony from the caseworker that it would be harmful to this child to cut off that relationship.
It was hard to see in the record from the December 7th hearing to the March 1st hearing in 2022, what changed that led to a decision to move forward with the termination trial?
My reading of the record, it's just a matter of time. Time is the only thing, that at some point, I think what the error that's happening in trial courts across the state is, it's giving parents time to rectify the condition, and then the second that the parent has not then rectified the ability to sort of physically care for a child, courts feel this pressure to then move forward and shift to terminating parental rights.
You're only a child for so long, right?
That's correct.
So this case, I think both of these cases have gone on for years and years and years, eating up most of these children's childhood. So you're saying it's wrong for the trial judge to say while these children are still children, that they deserve some stability and permanence?
Not at all. I actually think that what we are stipulating that children deserve that level of stability and permanence. I think what we dispute is that termination of parental rights is necessary to achieve that permanence and stability. I think that with the case with the children living with their grandmother, the legislature has created a vehicle, a juvenile guardianship, which the legislature itself defines as being a permanent arrangement.
So let me go to that and the distinction between in Dailey, right? There is in the statute, sub 4 of 712A.19A actually imposes a requirement on the trial court to determine whether these 5 permanency options are whether and if they must occur, right? So I think there is I understand that the agency may have sort of originally chosen the permanency determination, right? But there's an obligation on the court to go through that to see whether or not that is. And we can sort of talk about that, one of which being, as you've raised in Dailey, a legal guardianship. I'm struggling in Bates to see, is a custody order, like the custody order that has existed for the 4 years prior to termination, is that a permanency option? Because maybe it should be, but is it a permanency option that the court is empowered by statute to actually say it is? That's my question, because it would be the status quo, but that status quo keeps a court case open and the department involved in the lives of this family. So that doesn't seem like a permanency option to me.
So I have 2 responses. One, I think on a practical level, in trial courts across the state, many child protective cases are resolved through custody orders. It happens all the time with non-respondent parents. Other parents come to court, and that's how an ongoing child protective case is resolved, because that provides a child with stability in the same way that custody cases across the state provide children with stability. There are thousands and thousands of parents who they negotiate custody disputes.
Well, in fact, in Bates originally, that was, in fact, how the first petition was resolved.
Correct.
So a custody order said, the department said, we're good. We're dismissing the petition. What is left in place as the permanent option, obviously that didn't remain permanent or we wouldn't be here, but that was a permanent option and we're dismissing it and the case is closed.
Correct. And I think one of the options the trial court had in the Bates matter is to modify that custody order, to impose supervision requirements, whatever it deemed in that case to provide that stability. And the custody statute's clear that once the court made that determination, that the standard on my client to modify that is to prove by clear and convincing evidence that there's been a substantial and material change of circumstances. Which,
And just sort of bringing it back to the statute, to sub 4, where it says, you know, the court has to review these permanency options, reunification, termination, guardianship, placement with a fit and willing relative. Would you say this custody order sort of fits in that sub E, that it's another planned permanent living arrangement only if the others aren't an option?
it could, and one of the reasons I think that it's not listed specifically within 19A subsection 4 is oftentimes when there's a non-respondent parent, it is resolved far sooner than a permanency planning hearing, the custody order, because these things, if there's a willing and able parent, earlier in the process, courts often just resolve this case without waiting 12 months and all.
Is there authority in the statute that allows a court to do that?
I mean, the statute as interpreted is that courts can close the case at any point. At any point within the process, there's no requirement, for example, that a parent be given, going to Justice Clement's question about how long services need to continue. If a child is placed with a parent, there is nothing in the statute that says a case has to go on for a year. Or, I mean, a trial court routinely, even pre-adjudication, could resolve.
But you would have to admit that even if a child is placed with a parent, there could be a need to terminate the non-respondent parent's rights.
Not the respondent parent's rights, yes.
I'm sorry, the respondent parent's rights.
Yes, absolutely. And we have like regular cases within our clinic where a
they're
parent has
actively
committed.
causing harm or the potential to cause harm, like the maintaining that
Yes.
relationship causes some harm to the child.
Yes. And I think our position in this case, just to be clear, is that the evidence in this record doesn't satisfy that burden based on the testimony that was clear from the people who saw the interactions between Ms. Bates and the children. It was the caseworker, the
What about
supervising.
their therapist?
The therapist never actually observed a visit. In fact, both therapists, they're actually anticipating the question, reviewed both the testimony of both therapists. Neither of them met the saw the children with their mother. Neither of them met Mrs. Bates, and neither of them.
When you say neither of them, you mean?
There were two different therapists.
For the children.
For the children,
Yeah.
yes. And neither of them testified that continuing a relationship would be harmful to the children. And I would invite the court to take a close look at that testimony.
Who did observe the relationship between mother and the children?
There were three people. One was a visitation specialist who was contracted by the department to observe the visits. And she specifically testified that, that it would be detrimental to both children not to see their mother anymore. You also have the caseworker's testimony, and the caseworker testified that my client had a strong bond with the boys. The father also testified that the children had fun at the visits. That was kind of the way he had characterized the testimony. Those are the only three people on this record who saw the children interact with their mother.
So can I ask you a question? Typically, in these cases, and I will say I think that the most difficult ones are where the parent has had a lot of struggles and at some point starts to turn their life around, right, and do the things that they need to do and is fighting for the ability to remain a parent to their child. And we're running up of, like, have they done enough? Have they done enough for a long enough time? How do we do this? And most times, and I think that what we as a reviewing appellate court look to is the trial court's judgment of having seen from the bad to the improvement or relapses or whatever that may be over the course of this case. And we defer to that. Here, what I'm struggling with, at least in Bates, is we have almost 3 years of a trial court who saw these parents, saw the harm, the improvement, all of the things, and in those 3 years continued to decide that reunification efforts needed to be maintained, that visitation needed to be maintained, and then the decision to actually proceed to the termination trial was a different trial judge. Mm-hmm. And so when we're looking to who do we defer, now that different trial judge heard 3 days of testimony. and issued a 42-page decision considering, you know, all of these things. And I understand your position of saying all that she considered still wasn't sufficient. But which trial court are we supposed to sort of defer to in this instance?
Yeah, and this unfortunately happens more often than we'd like because of how long child protective cases often go. I think, and this isn't meant to sidestep your question, but I think that for us it's less about who you believe or whose judgment you defer to, and more about the framework that we're making these decisions within. And I think that, meaning, I think that it's not a question of did the trial court, because the trial court itself in Bates admitted in her ruling that there was a bond between the children and their parents and their mother. And based on the evidence, even the new trial court judge made that finding within her opinion. And for us, I guess that's a really operative fact in that the framework is, if that is true, then you at least have to ask the question and make a finding as to why an alternate remedy that could have given these kids their relationship with their mother while safeguarding their physical custody, whatever it might be, with their father, isn't a possibility. That they had actually achieved the type of stability that so many kids have. This is how they achieve stability when parents get divorced. And these kids did that, and the trial court could fine-tune that in any way it wanted to. And we don't see on this record where either the court in Bates or Dailey asked those questions. And I actually think one of the struggles that I wanted to get to is, and it's a privilege to get to talk about these issues with this court, because I think post-Mason, where in Re Mason, this court specifically said that a placement of a child with relatives weighs against termination. It's a direct quote from Mason where Justice Corrigan, writing the opinion, talked about how the kids were living with their aunt and uncle and could live there indefinitely while maintaining a relationship with their parents. What has happened post-Mason is I think trial courts don't know how to interpret that because there hasn't been any clarity about what that means. Right? And I think what we're trying to do in this case to a certain degree is operationalize that term to give trial courts a framework of what questions should we be asking to interpret that language.
So if in Dailey, if they had asked grandma specifically, what is your understanding of what a guardianship is compared to adoption? You are affirmatively opposed to the, is that the expectation? Is that the trial court, delve into that, put that on the record? What is the direction that you think that we need to give the trial courts?
I think that's exactly right. I think that testimony, either directly from the grandma or from the caseworker about, or somebody about whether these options were discussed with.
But I thought that there was something from the caseworker saying,
the caseworker simply,
yeah, she understood, she doesn't want to do it.
The caseworker just said that it was that guardianships were inappropriate because of the age of the child, and the child needed permanency.
Okay.
Was the testimony from the caseworker in the Dailey case. There is nothing that I saw on the record that indicated anything on the part of the grandmother about what she preferred, whether she had been informed about the fact that she could still get a subsidy.
You only have 2.5 minutes left. I want to ask this really quick.
And I'm happy to burn through my time and not rebut anything.
Okay. So you said that, yes, that's the direction that you think we need to give trial courts. Is it only when there's an established relationship with kin at that point in time? I mean, we're not expecting the caseworker to interview everybody. You understand what guardianship is. Would you do that? It's just when they've been placed with someone and they're moving away from that placement to something else. Whether that's termination, whether that's adoption. That's when those questions need to be taking place.
Correct. I think that in terms of the timeline, and there's this period of time where the efforts are being made to reunify the family, and then there comes a point that you're pivoting away from that determination where I think Justice Kavanaugh pointed out the 19A4 conversation where there's a range of options in the statute, and in figuring out which of those options to pursue, I think there are conversations with caregivers and people as to what they want, why they want it, making sure they're fully advised about the benefits that you could get. Even recently, the Michigan Department put out a press release saying they want to encourage more people to do subsidized guardianships because we just changed our relative licensing requirements. And so part of the struggle is, there's mixed messages that are given to caregivers and mixed messages from the department in its own manual about what are we doing?
I wasn't going to ask you this, but I'm going to now because
And I
of
have
what you just
questions
said.
too, once you're done.
Can you see, with the conversation that we're having, a necessity for the legislature to take a look at this? Because as you're indicating, you know, there's policy changes when it comes to funding, when it comes to the department. You know, can you see a way where the statute could be written to really be thinking about these alternatives?
If I could wave my magic wand, that we would rewrite much of the juvenile code because it would avoid a lot of the ambiguities that I often bring before this court. It is not a well-drafted statute. It was drafted originally in the 1930s, and a lot of these questions that that I think certainly there's more clarity in other states have done it in terms of the
But
types.
Can I just, would you agree that sub 4 that says that the trial court is required to determine whether and if applicable when these options are to be exercised, it doesn't rank adoption over guardian over alternate placement, with the exception of sub E, which is the sort of catch-all, if A through D aren't applicable, that. But I understand the DHHS guidance does rank adoption over guardianship. But the statute and what we're asking judges to do isn't saying you know, if adoption isn't an option, you know, adoption is better than guardianship is better than the next thing, right? The statute says you have to look at these permanency options and determine whether and if applicable when they have to be decided.
So I see my time is up. I'm
Yeah.
happy to answer your question if I may. You're absolutely correct that the statute does not have a hierarchy. Neither federal law or state law has a hierarchy giving preference to adoptions over any of the other forms of permanency. Okay. And I would further add that in the statute itself, it says that when kids are placed with relatives, you never have to, all the time limits to TPR don't even apply. And you can't get to an adoption unless you have a TPR. And so that's another, I think, indication that these cases involving family, and I want to make clear that my argument is very limited in that it's when kids are placed with family. It's a different framework.
Can I ask a factual question about in Dailey before you go? Am I correct that your client believed that the maternal grandmother was unfit and opposed guardianship and with her, and in fact the only guardianship, well, and also the lawyer clarified that he was not seeking a permanent guardianship? Do I have those facts correct? Or am I
There was a point in the case, Your Honor, where he did voice concerns about substance abuse by the maternal grandmother's son, who lived, you know, in the proximity of the grandmother's house. At the time of the termination trial, Mr. Dailey wasn't present. His attorney did recommend and ask the court to order a guardianship with the maternal grandmother who the child was living with.
temporary or permanent?
Permanent guardianship. In fact, Mr. Dailey stipulated to statutory grounds, saying that he couldn't care for the child. This was not a case where he was looking to regain physical custody of the child. It was all about, for him, the relationship.
Counsel, I have a couple questions. First, do we have to examine constitutional issues to decide this case? Can we just look at best interests and sort of layer into best interests potential harm, trauma from terminating? So I'm trying to figure out, can we decide this without grappling with the Constitution?
Absolutely. So, and I actually, like my invitation to operationalize what this court started in Operationalizing Mason which was purely a statutory framework decision.
Is that sort of, is it sort of this changing notion of what best interests are? Is that sort of where we are today? We've had a long time, many decades of best interests being based on stability and permanency and however that's defined. And you're basically asking us to define stability and permanency maybe a little differently.
Correct, and I think that's where the amicus briefs that were filed in this case, particularly the ones by the child-centered organizations like the Juvenile Law Center and the National Association of Counsel for Children, really document, I think, this changing notion of the harm that termination creates, and one that we shouldn't take lightly as we think about fashioning stability for children in a different way.
Thank you.
I'm well over my time. Thank you very much, Your Honor.
Thank you very much. Good morning.
Good morning, Your Honors. Jennifer Rosen on behalf of DHHS. Seated at council table is Solicitor General Ann Sherman and Assistant Attorney General Brittany Gatow, who authored the Dailey brief. In DHS's estimation, respondent's argument is twofold. First, on page 49 of the Bates brief, he says, quote, "If a child is equally protected and benefited by an option other than termination, termination isn't necessary." DHHS agrees with this. In fact, these outcomes short of termination happen each day as long as the child is equally protected and equally benefited, because the focus then remains on the child. Second, on page 49 of the same brief, he says, quote, "A parent's due process rights to family integrity require states to use the most narrowly tailored means of achieving the state's goal to protect children when terminating rights." The problem with respondent's second argument is that he's asking for an expansion of parents' rights when they have been adjudged unfit. The U.S. Supreme Court in Santosky examined the standards of proof for child welfare cases, deciding the constitutionally proper standard for statutory grounds is clear and convincing evidence because parents and children share an interest to prevent erroneous termination of rights. Santosky goes on to say that the shared interest ends as soon as the parent has been adjudged as unfit. Respondent ignores that the Santosky court recognized children have an interest in a normal family home. The interests of parents and children diverge at the best interest stage because children's interest in a normal family home more aligns with the state's interest in providing a stable home. Once a parent is adjudged unfit, children's interest in a normal family home is superior to any interest that the parent has. The focus shifts to the child, and the question becomes, should parental rights be terminated rather than can parental rights be terminated? Respondent's suggestion that parental rights can't be terminated if there is an option short of termination.
So tell me what happened from your perspective in Dailey between mom going to inpatient treatment. My understanding is got out, and the very next day in December of 2021 had a hearing where it was, it seemed like things were going well. Mom was doing, what she needed, what the court was expecting her to do, where she had struggled over the last couple years. And then we come to March 1st, and the reason I'm asking is because I have not seen the full record of the March 1st hearing. I've only seen pieces of it, and I feel like there's things missing. Why was there a decision at that point in time to move forward with termination when such a long period of time had gone, giving mom multiple chances, and then it seems like there was a period of time where things were going okay, and then there was the probation violation with the two instances. So what happened that then in March prompted this to move forward to a termination hearing?
In the Bates case, that petition, the last petition that was filed, that was an original petition seeking termination of parental rights.
When was that filed?
That was filed after AB1 went into DKA, so that had to have been in December of
19.
Right.
2019.
Okay, but so that's the petition we're talking about. But every time the court met, the trial judge said, let's keep going. I mean, the goal was still, even though that petition had been filed, the goal was still reunification at that time, or are you telling me no?
When the department files a petition files an initial petition seeking termination of parental rights, the goal is adoption. The goal is not termination. That is a means to get to an adoption or to get to a permanency plan. In this particular case, the permanent plan would not have been adoption because those two children were placed with their dad.
Okay, so once the department files a petition for termination, there's nothing that respondent parent can do during that period of time to change the department's mind.
No, that's not true at all. Of course there are things a parent can do to change the department's mind. The department in the Bates case was mandated to file an initial petition for termination because of the egregious circumstances surrounding AB1.
Understood, yep.
So, but the statute merely requires the department to file a termination petition. It doesn't mean that the department can't pivot and reduce the relief it requests or for the court to make a different decision.
Okay, so that was my first question, is what happened between what the court seemed to indicate that they were on board with, keeping mom and the boys having a relationship that, on a path towards something other than termination. And then March comes, and even the pieces that I saw on the record, it looks like the new trial judge even acknowledged that improvements had been made. But then we move to a termination trial.
I think what happened in this particular case is that the department filed the petition seeking termination of parental rights, and then COVID happened, and everything sort of got pushed, and this case was scheduled and scheduled and scheduled, all with the intent of having a hearing for termination of parental rights, but it just kept getting pushed because of COVID. That is certainly not typical of cases, and it is not typical of, it is just generally not typical of cases when initial petitions are filed.
Okay, so I'm just trying to understand. So in this case, when the petition for termination was filed, because of, as you said, the egregious nature of what prompted the petition, the department was always headed for termination.
Correct.
Okay, but you just said that they can shift and they can
They
be open.
can.
But in this case, there's no indication that they were. At every hearing with the judge, they were pushing to move forward to trial, to terminate her rights.
Yes. That was
Just-
always the department's intent.
Okay.
But the court was finding that services towards reunification and visitation were warranted, all the way up until December of '21. That December 7th, '21 hearing says visitation continues. Visitation continued even at the initial petition.
Visitation continues even when there is an original petition for termination.
Right,
For
and I
parents.
think what you're saying is that you can move for termination or file a petition for termination. Your goal, unless it changes, unless you see something that warrants a changing that permanency goal, but the court has a role to play as well, right?
Correct.
And the court from December of 19 through December of 21 is still saying that services towards reunification and visitation with mom are required. Those are warranted. And in fact,
Correct.
especially in December, when she says, I see market improvement this term, or this period, or whatever it is. And then the next hearing is in March, and a trial for termination is authorized.
Right, because the department had filed its petition for termination in December of 2019. Even though the department files a petition, an initial petition seeking termination of parental rights, the department can and still does work with parents
Sure.
in the time in between the petition being filed and getting to the point of determining whether or not termination is appropriate.
Do you agree with the question that I asked Mr. Sankaran, that a custody order in a situation where they're with a legal parent is a permanency option?
No,
But that was the basis, even in this case, for withdrawing the initial petition by the department.
Correct.
There was a custody order entered.
yes. There was a custody order entered that required the mother to participate in some sort of alcohol treatment and demonstrate sobriety for a period of time.
So if it's not a
She's-
permanency option, did the department just not follow it? I mean, they withdrew a petition after that original custody order was put into place.
Right, because that is the department trying to work with families to avoid having children come before a trial court.
So is that not a permanency option then?
It's not, well, it's not one of the 5 federally recognized permanency
But
options, and it
in
can't
practice,
fit
is
into,
that
and it can't fit
exercised
into
as one?
APLA. Because another permanent plan living arrangement, that is generally reserved for children who are 16 and older, who are going to, quote unquote, age out of the system. And we're providing them with different services in order to ready them for adulthood. So it's not, I mean, the only thing I could say that it could fit into is placement with a fit and willing
Then
relative.
what authority did the department have to withdraw its petition upon entry of the custody order the initial time?
Because the department believed that the issues that had plagued the mother had been resolved.
Okay, so if that were the same situation, a custody order, and I understand your position saying that that's not where we are now, or not where we were at the time of termination. But if the department had believed that that was the case, that a termination order could have been entered in the department's position, that would have been an acceptable permanency option.
A termination order or a
No,
custody order?
a custody order, I'm sorry. If mom had shown the improvement and you were again convinced that these children were safe and could be returned to her unsupervised, which is what happened in 18, and I understand that didn't remain the case, a temporary order is a permanency option. I'm
Well,
sorry,
the
a
department
custody
generally
order.
looks at it as dismissing to, dismissing to the parents, and then the parents, if they are equally footed, then can go to the friend of the court and have the friend of the court decide what custody arrangement works best for the children.
So DHHS doesn't take the position, we'll dismiss a petition if you get a custody order that says mom has to do certain things and has supervised visitation until that happens? Does DHHS play a part in that?
No, DHS may agree or not agree with the entry of a custody order, but the department doesn't get into the ins and outs of that order in terms of what it says, what the visitation is.
So even
Because
if the
DHS isn't a party to the
Yeah,
custody.
so even if the parties agreed to something that required a lot of respondent mom, you might look at that, but that doesn't, like in this situation, that is not going to in any way impact what the department decides on whether or not they're going to proceed with a termination.
Absolutely correct, yes.
Can I switch to Dailey for a minute and talking about guardianship and how that sort of process looks, right? And the decision-making that goes into it. As I said before, I read subsection 4 of 712A19A as requiring the court to determine when and if applicable, or whether and if applicable when, the following must occur, and gives all the 5 permanency options, including guardianship. And you may disagree with whether or not the statute ranks them. But then what I also looked at in terms of evaluating whether or not guardianship is a possibility, the DHHS guidance says, examples of reasons why adoption may not be appropriate include it's in the child's best interest to maintain the parental rights of the birth parents because the child and parent have a meaningful relationship as evidenced by attachment and regular visitation. However, the parent, due to physical, medical, or mental health disabilities, is unable to provide the day-to-day supervision and care for a child. So the department suggests that in those circumstances, a guardianship may be appropriate.
Yes.
Correct, okay. So if the department determines, or is, I guess, maybe even willing to sort of explore whether or not guardianship is a possibility, which I think we at least had the possibility here in Dailey, right? The department instructs its caseworkers that they must determine it's appropriate by completing a caseworker permanency planning checklist, and they must explain the differences between adoption and guardianship to the prospective guardian and child using MDHHS publication 140. Do we know in Dailey, in the record, if that requirement has been done?
Unfortunately, no. The record is silent as to that.
Okay.
And that actually is the case in the vast majority of cases. Whether caseworkers fulfill that obligation, that often doesn't get translated to the record. I agree that the record in these cases can be better. And when Your Honors asked Mr. Sankrin if he was, what guidance could we provide to the courts in terms of making decisions. Last night or yesterday, I actually looked at the case law surrounding best interests. And, it's unlike the Child Custody Act where there is an entire statute of factors that trial courts have to consider when deciding custody in the family court. I counted 20 factors in about 10 or 11 cases that have been issued by both this court as well as the Court of Appeals. And so the guidance is in so many places that I think it becomes difficult for trial courts to remember all of the different factors that they need to consider. The other point that I wanted to make, and Justice Viviano asked Mr. Sankrin about whether a guardianship could be permanent or temporary. There is no such thing as a permanent guardianship. There just isn't. While we want the guardianships to be viewed as more permanent and perhaps as a substitute for adoption, the fact is that there is no guardianship that is permanent, because the guardian has to renew their guardianship each year. And if they don't actively renew it, it lapses, leaving the children without legal custody. And in terms of a subsidized guardianship, the court has to determine that reunification and placement for adoption is not in the child's best interest and ruled out as a permanency option in order for prospective guardians to be able to receive a subsidy. So, guardianships absolutely can and do work in many of these situations, but they are not permanent.
Well, but, I mean, nothing is truly permanent, right? We know adoptions dissolve and disrupt to a certain amount.
Yes,
We know
it is.
that, yes, a guardian, I mean, there are, like, nothing is truly permanent.
No, but I have seen many more disturbed guardianships than I do see disturbed adoptions.
And that, is that the basis for why the department's policy is to prefer adoption over guardianship? Do you agree that that preference is not in the statute of what the judge is required to view?
Actually, because that the Michigan statute is from the Adoption and Safe Families Act, I disagree with Mr. Shankren that those are not ranked. I believe they are ranked in terms of, in order of preference. So with reunification being the most preferred, adoption being the second, guardianship, placement with a fit and willing relative, and then APLA.
Because, even though it's not stated, but because it's modeled on the federal?
Correct. Yes.
Counsel, is it appropriate for a trial judge to consider potential harm from the termination and trauma from that as part of the best interest analysis?
Say that once more, Your Honor?
Is it appropriate for the trial court judge to consider trauma to the child by, sort of the harm that's caused by terminating parental rights when there's an ongoing relationship, especially?
Absolutely, because the focus of the best interest hearing should be viewed through the lens of the child always. The rights of the child become superior to those of the parent at the point of the best interest determination. So
Did that happen in these cases? Because it seems like the record seemed, the people who, at least I think it said Bates, where they observed the only people in the record who saw the relationship firsthand, observed it, seemed to say that it was going to be harmful to terminate.
Well, correct, but I also think that the children's therapist's testimony is still valuable, even though they didn't observe any parenting time between the mother and the children, because they had been treating those children for well over a year at the point of termination. And so because they had been working with the two children and working with their mental health, I think that they were well within their authority to give their opinions about what would benefit and what would not benefit those children at that point in time.
Mr. Sankren's made the point that I think the positions taken by DHHS in these cases clashes with Mason. And why don't they? You disagree with that?
Yes, I disagree with that.
And why?
Because the statute says that a relative placement weighs against termination. A lot of trial courts and opposing counsel certainly have interpreted that as a bar to termination. The courts do consider relative placement. Are they explicitly stating that on the record? I think some judges and some referees do a better job of that than others, but I certainly think that, and have read enough transcripts to know that relative placement is taken into consideration when making the decision for termination of parental rights. I mean, some relatives can certainly transition into a guardianship and that works out fine. But other relatives, other prospective guardians, they can't, because the trial courts need to look at the not just the relationship between the parent and the child, but also the relationship between the caregiver and the child and the caregiver and the parent. Because how do those relationships factor in? Is the parent going to be a burden to that guardian? Is the parent going to interfere with that guardianship? And those are all legitimate questions to consider when determining whether or not a guardianship can work for a particular family. Because sometimes it works out as if we're closing the foster care case and getting the trial court out of it, but then we're just shifting the burden to the prospective guardian or the relative caregiver to then decide when visits are going to be appropriate, to navigate, potentially having somebody who is a drug user or an alcohol user in their home. And I think that a lot of the caregivers and guardians, we're shifting this burden to them. We're not necessarily giving them any funds to raise the child, and then they're left to navigate this whole situation without any assistance from the state.
Okay, thank you. I do know the legislature has looked into that and has taken some recent action, so, but I realize it's a narrow group, so thank you.
Thank you both. The
Thank
case
you,
will be
Your Honors.
submitted.